by Ranking Member Senator Roberts and Chairman Schumer, and then we will hear from Justice Stevens, and following his testimony we will have the panel, and if other senators join us during the course, they will deliver their opening statements after Justice Stevens joins us. I'm deeply worried about the future of our democracy. For over 100 years, we have struggled with the issue of money in politics, always seeking to find the right balance between freedom of political expression and the corrosive influence of the unchecked flow of money to public officials. We've had periodic scandals and periodic corrections. We've had new laws and new ways to evade those laws. But we've never before seen what is happening today. As we will learn this morning, a perfect storm of new forces, court opinions, clever political operatives, and the high stakes inherent in governmental decisions have created a qualitatively new political landscape where candidates are compelled to raise more and more money and yet, at the same time, have to contend with virtually unlimited spending by shadowy entities representing nameless donors. What has occurred in the past 5 years represents revolutionary, not evolutionary, change in the way campaigns are financed in America. These are changes I view as a threat to undermine the fundamental principle of American democracy: one person, one vote. They're well-intentioned people who I respect, who believe that restrictions on who can give to campaigns and how much they can give trespass on cherished First Amendment freedom of speech protections. Others, and I'm among them, are worried that the recent decision's elimination of even modest limits on campaign contributions, combined with a Byzantine system that in too many cases masks disclosure of who is giving and allows a so-called flood of so-called dark money into the process, has the very real potential to corrode the integrity of the system itself. Historically, the flow of money has rested in and out of political campaigns on three pillars: regulation of sources, regulation of amounts, and disclosure. Recent decisions have severely restricted our ability to control sources and amounts. But in those decisions, and I'm referring, of course, to Citizens United and McCutcheon, the court has explicitly invited Congress to utilize disclosure as the protection of the public interest in these situations. Justice Kennedy and Justice Roberts, in their opinions, cite disclosure as the reason that the limitations don't have to be upheld. Unfortunately, the disclosure requirements that they mention in those opinions as the bulwark against abuse and corruption simply don't exist. For example, according to a new study by the Center for Responsive Politics, total independent expenditures reported to the FEC by outside groups totals about $70 million to this point in 2014, nearly 3 times more than was spent at this point in 2010. That's the point I want to emphasize, is that this isn't a gradual growth of a change of a few dollars here and there. What we have is an explosion of this kind of money, not only of outside expenditures, but also of expenditures where we don't know the source. We've created a kind of parallel universe of campaign finance: the traditional candidate-based system with clear limits on sources and amounts and strict disclosure requirements, and the independent system with no control of sources, no limits, and no disclosure. Naturally, this troubling new world of campaign finance impacts how we as elected officials interact with the fundraising process. Quantitatively, in the amounts of money that elected officials need to be made. An average U.S. senator, and of course all senators are above average, but an average U.S. senator running for re-election has to raise something on the order of $5,000 to $8,000 a day, every day, 365 days a year for 6 years in order to accumulate the funds necessary to run for re-election. And I can tell you at the rate of $5,000 to $6,000 a day, you very quickly run out of friends and family. My concern here is the system. This isn't a Democratic or a Republican issue, and the country does not benefit from an undisclosed contribution and an arms race in contributions. Disclosure in this context is not an infringement on the First Amendment, but what we are allowing to happen before our eyes is already having its inevitable effect: the erosion of confidence in our system and in us as stewards of our country's future. The challenge here, the challenge before us, is to find the balance between competing goods, the freedom to exercise our political voice on the one hand, and the public's interest in safeguarding the integrity of the political process on the other. To restore that balance in what feels like an increasingly unbalanced system. I welcome our witnesses today and look forward to their contributions to these important deliberations. Senator Roberts.
Well, thank you, Mr. Chairman. I'm pleased to be here today on this very important subject, and I brought my own chart. We in the minority do not have enough money for another display unit over there, so I would ask unanimous consent we could put our chart up where you had your chart.
Without objection.
The chart bears the text of the First Amendment to the Constitution of the United States. And I believe that is what we are talking about today. The rights of citizens to express themselves, to make their views known on the issues that affect their daily lives and pocketbooks or any other issue they wish to discuss. The First Amendment protects those rights and it prevents the government from restricting them. The exercise of those rights does not threaten our democracy. It is the attempt to restrict these rights that we must fear. We are living today with the consequences of the failed attempt to restrict them. This failure was not hard to foresee. It is not the fault of the courts or the Federal Election Commission. It is the direct consequence of the poor decision Congress made when it passed the McCain-Feingold bill. I opposed that bill. I and others who voted against it did so because we knew it would restrict people's rights to participate in the political process. It would not get money out of the system, but would simply divert it to other avenues. Supporters of the bill, of course, denied it. They assured us it would not happen, that our system would be better. It should be clear now who was right and who was wrong. But rather than admit they were wrong, the proponents of speech regulation have just proposed new regulations. Because the courts have properly found much of their last effort to be unconstitutional, they have proposed new regulatory schemes under the guise of disclosure. No longer able to simply prohibit speech they do not like, they seek to prevent it by imposing onerous disclosure requirements on those who wish to speak. Now, respectfully, Mr. Chairman, as we consider suggestions for ways to improve the system, the last people we should be asking for advice at this hearing are those who helped write the law that created the problem in the first place. Let's stop this fool's errand of speech regulation. Let's stop trying to prevent people from criticizing us. Let's stop demonizing citizens who exercise their First Amendment rights. Let's stop pretending more speech somehow threatens our democracy. We have nothing to fear from a free marketplace of ideas. We do, however, need to fear a government empowered to investigate its own citizens for exercising their rights. The revelations of the Internal Revenue Service targeting of conservative groups and others have shown this to be a real danger. We hear a lot about corruption when this issue is debated. I think for many people that the definition of corruption is the promotion of ideas with which they disagree. It is amazing how for years George Soros has been spending millions of dollars to promote liberal and progressive causes. None of my friends on the other side of the aisle seem to be concerned about it. Now that the Koch family is spending money to promote free markets and private enterprise, we are supposed to believe that our democracy is at risk. That is absurd. Corporate spending is supposed to be a concern, but corporations have long exercised unfettered rights to express themselves, provided they were media corporations. I am pleased to say that the Citizens United case changed that. The Supreme Court recognized the First Amendment does not allow this Congress to choose who gets to speak and properly ended this nonsensical distinction, with the only consequence being that now more voices are heard. And I know, there are some in this body who do not want those voices to be heard, and they're doing everything they can to silence them. Our majority leader, unfortunate, who has a fixation with the Koch family that can only be described as bizarre, takes to the floor on an almost daily basis to attack them. Why? I think it's because he fears they pose a threat to his hold on power, or the majority. He wants them to stop talking. Well, that is why the First Amendment begins, Congress shall make no law. The First Amendment doesn't allow us to silence those who oppose us. That applies to corporations, labor unions, Mr. Soros, and the Koch family. It applies to everyone. Let's stop trying to do so, Mr. Chairman. Let's stop trying to impose regulations designed to deter and harass our opponents. Instead, let's just admit the mistake we made when we tried to regulate political speech in the first place. Let's remove those restrictions. Let's allow those who want to contribute and engage in our political system to give money where they want, as long as they follow the law. Everyone in this country has the right to express themselves, Mr. Chairman, even people who don't manage to get themselves invited to appear on television shows or to testify at Senate hearings. People, all people, individually and as groups, have every right to make their views known. Instead of trying to stop them, let's reinvigorate our system. New restrictions and regulations are not going to improve the system. Getting rid of those we already have imposed will. That is the course we should take, Mr. Chairman. Simply, let's just do it. Thank you for your time.
Senator Schumer.
Thank you. And first, let me thank you, Senator King, for suggesting this hearing and for your chairing the hearing, as well as your invitation to Justice Stevens, who I look forward to hearing from. Well, I think McCutcheon is a real turning point in our debate about money in politics. McCutcheon seemed to say that free speech, absolutely defined as McCutcheon does, allows anyone to spend any amount of money in any way in our political system. McCutcheon, carried to its logical extreme, will get rid of individual limits, will get rid of limits on corporations, will just allow money to totally envelop our system. It is frightening. It is frightening. And the reason we have this hearing is not because of some new ads. Koch brothers have been doing ads for years and years, but because of the McCutcheon decision and its implications for our democracy. The bottom line is very simple. I respect my colleagues' fidelity to the First Amendment, but no amendment is absolute. Most of my colleagues on the other side of the aisle support anti-pornography legislation. That's a limitation on the First Amendment. Most everyone here believes you can't falsely scream fire in a crowded theater. That's a limitation on the First Amendment. We have many different laws that pose limits on the amendments because through 200 and some odd years of jurisprudence, the Founding Fathers and the Supreme Court have realized that no amendment is absolute. We have noise ordinances. Everyone accepts them. That's a limitation on the First Amendment. So if you impose a view that just when it comes to allowing one person to put the 7,1112th ad on television, that the First Amendment's absolute, but in so many other areas it's not, you have to ask why. You have to ask why. And then when many on the other side of the aisle don't support disclosure, which is actually an enhancement of the First Amendment, free debate, free knowledge, one wonders why. One wonders why. The First Amendment protection of free speech is part of what makes America great. So is the concept of one person, one vote. And when a small group of people, 700 in this case, who were affected by McCutcheon, have so much more power to influence the political process than everybody else, our democracy is at risk. That's the problem here. There's a balancing test. And there are many concepts in the Constitution. The concept of having a somewhat level playing field so that those who have overwhelming wealth and choose to spend it, whether they be on the left or the right, the laws we're proposing affect the Koch brothers and George Soros, and should, are important. And so, because now legislation could bring disclosure, but will not stop the path McCutcheon is on, Senate Democrats are going to vote this year on my colleague Tom Udall's constitutional amendment, which once and for all would allow Congress to make laws to deal with the balance between equality, each vote is equal, each person is equal, and the First Amendment, a careful balance, but not what the 5 members of the Supreme Court have said, no balance. We will bring that amendment to the floor shortly, and we will vote on it. And I will be working with Senator Udall and Majority Leader Reid and hopefully every Republican who cares about honest elections to bring it to the floor this year. When the Supreme Court or any of my colleagues say that the Koch brothers' First Amendment rights are being deprived, that they're not being heard, it defies common sense. It defies logic. And the same would apply to some very liberal person who put on 10,000 ads. The ability to be heard is different than the ability to drown out every other point of view using modern technology simply because you have a lot more money than somebody else who has an equally valid view. So I hope that Senator Udall's amendment will attract bipartisan support, but it will draw to a fine point where we are at, and that is that the First Amendment is sacred, but that the First Amendment is not absolute. And by making it absolute, you actually make it less sacred to most Americans. We have to bring some balance to our political system. If people lose faith in this system, which they are rapidly doing in large part because they feel correctly that people with a lot of money have far more say in the actual political dialogue than they do, this great democracy could falter. We don't want it to happen. And the best way to stop it is to show the Supreme Court or limit the Supreme Court, show them that their absolutist view is wrong, and support an amendment like Senator Udall's. Thank you, Mr. Chairman.
For the information of Senator Cruz, Senator Walsh, and Senator Udall, who arrived after my introduction, the schedule we're going to follow is I'm now going to invite Justice Stevens to speak, and then each of you will be asked to provide a statement if you wish to do so. Justice Stevens, if you would join us at the table. Justice John Paul Stevens is a retired Justice of the United States Supreme Court, was appointed to the court in 1975 by President Gerald Ford, I think the third longest sitting Justice of the Supreme Court. And Justice Stevens, I knew that you were a distinguished jurist, but my eye was caught by a headline in the paper over the weekend that says, Pope to move John Paul for sainthood. And I realized later it wasn't the same John Paul, but in any case, we're delighted to have you here today. Thank you very much for joining us, Justice.
Thank you very much, Senator. Senator King, Chairman Schumer, Ranking Member Roberts, and distinguished members of this committee, I thank you for the opportunity to appear before you today to discuss the important issue of campaign finance. When I last appeared before this body in December 1975, my confirmation hearing stretched over 3 days. Today, I shall spend only a few minutes making 5 brief points. First, campaign finance is not a partisan issue. For years, the court's campaign finance jurisprudence has been incorrectly predicated on the assumption that avoiding corruption or the appearance of corruption is the only justification for regulating campaign speech and the financing of political campaigns. That is quite wrong. We can safely assume that all of our elected representatives and candidates for office are law-abiding citizens, and their laws against bribery provide an adequate protection against misconduct in office. It is fundamentally wrong to assume that preventing corruption is the only justification for laws limiting the First Amendment rights of candidates and their supporters. Elections are contests between rival candidates for public office. Like rules that govern athletic contests or adversary litigation, those rules should create a level playing field. The interest in creating a level playing field justifies regulation of campaign speech that does not apply to speech about general issues that is not designed to affect the outcome of elections. The rules should give rival candidates, irrespective of their party and incumbency status, an equal opportunity to persuade citizens to vote for them. Just as procedures in contested litigation regulate speech in order to give adversary parties a fair and equal opportunity to persuade the decision maker to rule in their favor, rules regulating political campaigns should have the same objective. In elections, the decision makers are voters, not judges or jurors, but that does not change the imperative for the equality of opportunity. Second, all elected officials would lead happier lives and be better able to perform their public responsibilities if they did not have to spend so much time raising money. Third, rules limiting campaign contributions and expenditures should recognize the distinction between money provided by their constituents and money provided by non-voters, such as corporations and people living in other jurisdictions. An important recent opinion written by Judge Brett Kavanaugh of the D.C. Circuit and summarily affirmed by the Supreme Court, Blumen against the Federal Election Commission, upheld the constitutionality of the federal statute that prohibits foreign citizens from spending money to support or oppose candidates for federal office. While the federal interest in preventing foreigners from taking part in elections in this country justified the financial regulation, it placed no limit on Canadians' freedom to speak about issues of general interest. During World War II, the reasoning behind the statute would have prohibited Japanese agents from spending money opposing the re-election of FDR, but would not have limited their ability to broadcast propaganda to our troops. Similar reasoning would justify the state of Michigan placing restrictions on campaign expenditures made by residents of Wisconsin or Indiana without curtailing their speech about general issues. Voters' fundamental right to participate in electing their own political leaders is far more compelling than the right of non-voters, such as corporations and non-residents, to support or oppose candidates for public office. The Blumen case illustrates that the interest in protecting campaign speech by non-voters is less worthy of protection than the interest in protecting speech about general issues. Fourth, while money is used to finance speech, money is not speech. Speech is only one of the activities that are financed by campaign contributions and expenditures. Those financial activities should not receive precisely the same constitutional protection as speech itself. After all, campaign funds were used to finance the Watergate burglaries, actions that clearly were not protected by the First Amendment. Fifth, and this perhaps is the most important thing I want to say, is the central error in the court's campaign finance jurisprudence is the holding in the 1976 case of Buckley against Vallejo that denies Congress the power to impose limitations on campaign expenditures. My friend Justice Byron White was the only member of the court to dissent from that holding. As an athlete and as a participant in Jack Kennedy's campaign for the presidency, he was familiar with the importance of rules requiring a level playing field. I did not arrive at the court in time to participate in the decision of the Buckley case, but I have always thought that Byron got it right. After the decision was announced, Judge Skelly Wright, who was one of the federal judiciary's most ardent supporters of a broad interpretation of the First Amendment, characterized its ruling on campaign expenditures as, quote, tragically misguided, unquote. Because that erroneous holding has been consistently followed ever since 1976, we need an amendment to the Constitution to correct that fundamental error. I favor the adoption of this simple amendment. Quote, neither the First Amendment nor any provision of this Constitution shall be construed to prohibit the Congress or any state from imposing reasonable limits on the amount of money that candidates for public office or their supporters may spend in election campaigns, unquote. I think it wise to include the word reasonable, to ensure that legislatures do not prescribe limits that are so low that incumbents have an unfair advantage or that interfere with the freedom of the press. I have confidence that my former colleagues would not use that word to justify a continuation of the practice of treating any limitation as unreasonable. Unlimited campaign expenditures impair the process of democratic self-government. They create a risk that successful candidates will pay more attention to the interests of non-voters who provide them with money than to the interests of the voters who elected them. That risk is unacceptable. Thank you.
Mr. Justice, thank you very much for your considered remarks. We appreciate your willingness to share them with us here today.
Thank you very much.
You're excused. In accordance with the process that we discussed at the beginning, I'll now turn to Senator Cruz for an opening statement if you choose to make one.
Thank you, Mr. Chairman, and I'd like to thank Justice Stevens for being here and joining us. Prior to being in the Senate, I spent much of my professional career as an advocate before the court, and I must say it is a different position to be on this side of the dais rather than answering questions from Justice Stevens. And I will note that of all of the justices, Justice Stevens often disagreed with the position of my clients, and there was no justice whose questions were more incisive, more friendly, and frankly more dangerous than Justice Stevens. Always with a twinkle in an eye, he would ask a question Counsel, wouldn't you just agree with this small little thing that if you said yes would walk you down a road that would unravel the entire position in your case? And so it is very nice to have the good justice with us. And I want to thank all of the witnesses who are here for our second panel as well. This topic is a topic of great import. The entire Bill of Rights, the First Amendment, is the most important. It is the foundational right of every other right that is protected of citizens. And I will say that in the issue of campaign finance reform, this is perhaps the most misunderstood issue in all of politics. Because campaign finance reform restrictions are always pitched as, let's prevent corruption, let's hold politicians accountable, and they do exactly the opposite. Every single restriction this body puts in place is designed to do one thing: protect incumbent politicians. And it's powerfully good at that because at the end of the day, there are three speakers in a political debate. There are politicians, there is the media, and there are the citizens. Campaign finance reform is all about silencing number three so that the politicians can speak unimpeded. And I will say, there are colleagues of mine in both parties who will stand up and say, these pesky citizens groups, they keep criticizing me. Well, that is the nature of our democratic process. And if you choose to run for public office, there are 300 million Americans who have a right to criticize you all day long and twice on Sundays. That's how our system was built. And I will tell you this, I am certainly one who will defend the rights of our citizens to speak out, whether I agree with their speech or not. The Sierra Club has an absolute right to defend their views, as does the NRA. Planned Parenthood has an absolute right to defend its views, as does the National Right to Life. That is the way our system operates. And campaign finance reform is all about lower the limits, restrict the speech. And what happens is the only people who can win elections then are incumbent politicians. Because incumbent politicians have armies of lobbyists and entrenched interests that raise the money and fund them, and any challenger that comes across has to raise the money. And if you don't have an army of thousands upon thousands of bundlers, you cannot effectively challenge an incumbent. And that is not the unintended effect of these laws, that is the intended effect. Our current system makes no sense. Right now we have super PACs that are speaking on the sidelines. And you have politicians who played games. They speak, since they cannot speak directly under the law, they simply will say, who will rid me of this troublesome cleric? And a group springs up and speaks, and if this group is supporting you, you kind of hope what they say bears some resemblance to what you believe, but you're not allowed to talk to them. So if they happen to get it wrong, there's not a darn thing you can do. A far better system would be to allow individuals unlimited contributions to candidates and require immediate disclosure. As John Stuart Mill said, let the marketplace of ideas operate, let more speech counter bad speech, rather than this silly game we play right now. Now, I will note there are a series of canards that get discussed in this issue. The number one canard is money is not speech. We can restrict money because it has nothing to do with speech. That statement is categorically, objectively false. Money is and has always been used as a critical tool of speech, whether publishing books, or putting on events, or broadcasting over the airwaves. And I would suggest to each of the witnesses and to everyone thinking about this issue, ask yourself one question for every restriction that members of Congress or advocates put forth. Ask yourself one question: would you be willing to apply that same restriction to the New York Times? And let me note, the New York Times is a corporation, so everyone who says corporations have no rights, fine. There are some who say, let's restrict political speech within 90 days of an election. Very well then, would you be willing to say the New York Times may not speak about politics within 90 days of an election? McCutcheon said you can't tell citizens they can only support 9 candidates. If they want to support 10 or 11 or 12, they're entitled to do so. If you think McCutcheon is wrong, would you be willing to tell the New York Times, you may only speak about 9 candidates, or only candidates in New York? Look, those restrictions are all obviously and facially unconstitutional, and I would ask you, why does a corporation like the New York Times or CBS or any other media corporation, in Congress's view, enjoy greater First Amendment rights than individual citizens? Our democratic process is broken and corrupt right now because politicians in both parties hold on to incumbency. We need to empower the individual citizens, and I'll say this in closing. I agree very much with Justice Hugo Black, who famously said with regards to the First Amendment, the words, "Congress shall make no law abridging the freedom of speech," means exactly what it says. No law means no law, and we should be vigorous protecting the rights of individual citizens to be engaged in the political process and to hold every one of us on both sides of the aisle accountable. It's the only thing that keeps our democratic process working. Thank you, Mr. Chairman.
Senator Udall.
Thank you very much, Chairman King, and good morning, and thank you for holding this very important hearing. I want to thank the witnesses that I know are going to be here later to discuss what I think is a very, very important topic. And let me say to the Chairman of the Rules Committee, Chairman Schumer, I really appreciate your statement about we're going to have a vote this year on a constitutional amendment. I think it's about time. We've had several votes. I think we had one in '97. We had one in 2001. But these rulings by the Supreme Court have gone so far that we're really ripe for having a vote and trying to coalesce around something. I know that Justice Stevens is left, but I want to say the words I had in my statement to him. I'm sure it will get to him. As the author, Justice Stevens, of the dissent in Citizens United, you wrote that, quote, "The court's ruling threatens to undermine the integrity of elected institutions across the nation." And I have found myself agreeing with Justice Stevens, and unfortunately, this is another of those times. 4 years after Citizens United, the damage continues. The court's decision this month in McCutcheon was one more step in dismantling our campaign finance system. It's now crystal clear an amendment to the Constitution is necessary to allow meaningful campaign finance rules. And as I heard Chairman Schumer talk about the issue of it being absolute, that's what we're talking about, is allowing meaningful campaign finance rules, not in any way abridging the First Amendment. Most Americans don't have unlimited dollars to spend on elections around the country. They only get their one vote. They can support one candidate, the one who represents their district or state, but for the wealthy and the super wealthy, McCutcheon says they get so much more. That decision gave them a green light, full speed ahead to donate to an unlimited number of candidates. Now a billionaire in one state gets to influence the elections in 49 other states. Under McCutcheon, one donor can dole out $3.6 million every 2 years, just like that. Consider this: an American citizen working full-time, making minimum wage, would have to work 239 years to make that kind of money. 239 years. The court has shown a willingness to strike down sensible regulations by a narrow majority and is returning our campaign finance system to Watergate-era rules, the same rules that fostered corruption, outraged voters, and promoted campaign finance standards in the first place. But our campaign finance system was in trouble long before. The Citizens United and McCutcheon decisions just picked up the pace. The court laid the groundwork many years ago, and I know Justice Stevens mentioned this in the case of Buckley versus Vallejo. It goes all the way back to 1976. The court ruled that restricting independent campaign expenditures violates the First Amendment right to free speech. In effect, money and speech are the same thing. This is tortured logic, and ignores the reality of political campaigns. The outcome is not surprising. Elections have become more about the quantity of cash and less about the quality of ideas, more about special interests and less about public service. We have a broken system based on a deeply flawed premise. That's why I introduced S.J. Res. 19 last June. It now has 35 co-sponsors, and I think I believe Senator King and Senator Schumer are both on it. It's similar to bipartisan resolutions in previous Congresses. Actually, it started with Senator Stevens, I believe, back in 1983, so it has true bipartisan roots and is consistent with the amendment that Justice Stevens has proposed. It would restore the authority of Congress, stripped by the court, to regulate the raising and spending of money for federal political campaigns. This would include independent expenditures, and it would allow states to do the same at their level. It would not dictate any specific policies or regulations, but it would allow Congress to pass sensible campaign finance reform that withstands constitutional challenges. In the Federalist Paper number 49, James Madison argued that the U.S. Constitution should be amended only, and he used this term, only in great and extraordinary occasions should we go with a constitutional amendment. And I agree with him. I also believe we have reached one of those occasions. Free and fair elections are a founding principle of our democracy. They should not be for sale to the highest bidder. This effort started decades ago. There is a long, and I might add, bipartisan history here. Many of our predecessors from both parties understand the danger. They knew the corrosive effect money has had on our political system. They spent years championing the cause. In 1983, the 98th Congress, Senator Ted Stevens introduced an amendment to overturn Buckley. And in every Congress from the 99th to the 108th, Senator Fritz Hollings introduced bipartisan constitutional amendments similar to mine. Senators Schumer and Cochran continued the effort in the 109th Congress. And that was before the Citizens United and McCutcheon decisions, before things went from bad to worse. The out-of-control spending before Citizens United has further poisoned our elections, but it has also ignited a broad movement to amend the Constitution. McCutcheon is the latest misguided decision, but it won't be the last. It's time for Congress to take back control and pass a constitutional amendment. And again, Chairman King and Chairman Schumer, I thank you for holding this hearing, and I think it's very, very timely on the heels of McCutcheon. Appreciate it.
Thank you, Senator. If our next panel could take their seats, I will introduce you. We're going to hear from this panel in alphabetical order. First is Mr. Donald F. McGahn, a partner with the law firm of Patton Boggs. Previously, he was a commissioner and chairman of the FEC. He also served as the general counsel for the National Republican Congressional Committee for 10 years. Second is Norman Ornstein, resident scholar at the American Enterprise Institute, well-known columnist and frequent commenter on campaign finance issues. Third is Mr. Trevor Potter, president and general counsel for the Campaign Legal Center. Previously, he was a commissioner and chair of the FEC and later served as general counsel to John McCain's 2008 presidential campaign. Fourth, Ms. Ann Revelle, former chair of the California Fair Political Practices Commission, currently vice chair of the Federal Election Commission. And finally, Neil P. Reif, who is a founding member of the law firm of Sandler, Reif, Young, and Lamb, and a former deputy general counsel for the Democratic National Committee. Thank you all for joining us today, and I welcome your opening statements. And if you have more lengthy statements, they can be submitted for the record, but we look forward to hearing from you, and then we will discuss these issues. Mr. McGahn.
Chairman King, Ranking Member Roberts, and members of the committee, thank you for the opportunity to appear before you today. It's an honor and a privilege, particularly in light of the appearance of former Justice John Paul Stevens. Per the committee's request, I submitted written testimony prior to the hearing, jointly filed with another panelist here today, Neil Reef. Mr. Reef and I are practitioners in the area of campaign finance, and our views are shaped by decades of experience in advising and representing real people who wish to participate in politics in a legally compliant manner. Although we have similar clients and are not here to represent the views of any of those clients, we differ in one significant way. One of us represents Republicans, conservatives, and libertarians, while the other represents Democrats, liberals, and progressives. Such a partisan difference in the modern world would ordinarily preclude any notion of common ground, but not here. Recently, we co-authored an article that was published in Campaigns and Elections magazine that explained our views on the good, the bad, and the ugly of the current law, particularly the aspects imposed by the Bipartisan Campaign Reform Act of 2002, commonly called McCain-Feingold. In our article, which we have already submitted to the committee, we explained that much of what many perceive to be the problems in the current system can be traced back to the underlying statute itself. As we predicted back in 2002, McCain-Feingold has become a warped version of itself, where heavily regulated candidates and party committees have taken a back seat in our current system. We suggest a different approach, one that flows from a different premise, firmly grounded in our shared First Amendment tradition, that in order for voters to be truly informed, they need to hear directly from the candidates themselves. Thus, the candidate's voice ought to be the central voice in American democracy. In our view, the parties are the best vehicles to assist with achieving that goal. In other words, political parties are uniquely situated to echo their candidate's message. Critically, our views and suggestions are not designed to simply transfer relevancy back to the parties for relevancy's sake. Recall that the plaintiff in Buckley versus Vallejo, Senator James Buckley of New York, was not nominated by either of the two major parties. And it was precisely that sort of candidate, one outside of that era's establishment, that felt the burdens of that wave of reform the most. We care first and foremost about grassroots and local activity by ordinary citizens and believe that McCain-Feingold, in its effort to change the culture of Washington, D.C., has reached too far into state and local politics and contributed to pushing local activists outside the parties. Unfortunately, current law has placed parties at a competitive disadvantage and has federalized virtually all state and local party programs. Which brings us to the 2014 campaign landscape. Certainly, direct contribution limits remain, albeit at artificially low levels that do not match the rate of inflation that has occurred since they were first instituted. For example, the $10,000 state party limit in today's dollars ought to be, if adjusted for inflation, about $48,000. In addition to regular inflation, the cost of campaigning has skyrocketed, particularly due to the cost of television advertising. Other prophylactic measures imposed by the law have been struck by the courts, except those that limit the ability of political party committees to effectively assist their candidates. Candidates are struggling to be heard over the din of single issue and other groups, and the party committees, who historically have been a candidate's natural ally, has significantly diminished and essentially been replaced by independent super PACs and single issue nonprofits. To us, this seems backwards and ironically is the opposite of the goal of so-called reform. Some claim more disclosure is the answer. Separate and apart from my work with Mr. Reef, in my own view, this is not the answer. Certainly, campaign disclosure has survived judicial review, albeit in a more limited form than that which was originally passed. But disclosure has had a mixed record in the courts, sometimes upheld, but often struck or limited. Whether one looks to Talley versus California, Thomas v. Collins, NAACP versus Alabama, Buckley versus Vallejo, or most recently Davis versus FEC, disclosure has its limitations. As Justice John Paul Stevens himself said, writing for the court's majority in McIntyre versus Ohio, quote, "Anonymity is a shield from the tyranny of the majority. It thus exemplifies the purpose behind the Bill of Rights and of the First Amendment in particular," unquote. Justice Stevens also said, speaking for the court, quote, "The freedom to publish anonymously extends beyond the literary realm," unquote. Continuing, on occasion, quite apart from any threat or persecution, an advocate may believe her ideas will be more persuasive if the readers are unaware of her identity. Anonymity thereby provides a way for a writer who may be personally unpopular to ensure that readers will not prejudge her message simply because they do not like its proponent. Thus, even in the field of political rhetoric, where the identity of the speaker is an important component of many attempts to persuade, the most effective advocates have sometimes opted for anonymity, unquote. And what of McCutcheon versus FEC? We anticipate that McCutcheon will help address the unfairness to parties and most candidates to some degree, but it did not strike limitations and prohibitions on direct contributions to candidates and party committees. What was struck was a so-called biennial limit, essentially an umbrella limit that prevented citizens from giving to more than a few handful of candidates and party committees. Thus, the impact of McCutcheon. More candidates, including challengers and those that are not seen as safe bets, will have access to additional financial support. Hopefully, direct contributions will no longer be the province of a select few well ensconced within the ruling class. Similarly, the upstart challenger candidate's natural ally, the political party, will no longer have to compete with each other for resources to the degree caused by McCain-Feingold. But this sort of change is not enough to fix what ails our system of privately funded campaign finance. McCain-Feingold must be revisited. Thank you for the opportunity to present these views.
Thank you, Mr. McGahn. Mr. Ornstein.
Thanks so much, Mr. Chairman, and it's really a pleasure to be here to talk about this issue. I want to start by commending Senator Cruz for his full-throated support of disclosure, and I look forward to his vote for the Disclose Act when it comes up in the Senate.
I wrote that down myself.
I also want to thank Senator Roberts for putting up the text of the First Amendment, which I read and reread as I have done so many times, and I'm still looking for the word money in the First Amendment. And I just have to say that if money is defined as speech, then the rights of citizens as equals in this process to participate simply gets blown away. Those who have lots of money have lots of speech. Those who have little money have very little or no speech. Having said that, I want to really talk about two larger concerns that are generated by the multiple recent moves that I believe have knocked the pins out from under the regulatory regime that has long operated in American politics. I wrote my testimony going back to the Tillman Act in 1907, but as I've reflected on it, it really does take us back at least to the 1830s. And the two things I want to talk about are, first, the corrosive corruption that's caused when you remove the modest limits on money that have existed. And second, a real focus of the hearing, of course, is the efforts to limit disclosure and enable these huge flows of dark money to enter the system without the accountability necessary in a democratic political system. As I look through history, what we know is that the focus on corruption, the concerns about corruption and money, are not new at all. They go back at least to an attempt in 1837 to prohibit the parties from shaking down government employees and giving contributions. As historian John Lawrence noted, Abraham Lincoln, who I believe was a Republican, warned that concentrated capital had become, quote, enthroned in the political system, and he worried about an era of, quote, corruption in high places until the republic is destroyed. I have to believe that if Abraham Lincoln were around today, he would be reinforced in that particular judgment. As we went through the corruption in the Grant administration that led to the Pendleton Act in 1883, the corruption involving outsized corporate influence on President Theodore Roosevelt that led to the Tillman Act in 1907, the Teapot Dome scandal that resulted in the Federal Corrupt Practices Act of 1925, the abuse of federal employees that led in 1938 to the passage of the Hatch Act, the Taft-Hartley Act in 1947, the Watergate scandal spurring the Federal Election Campaign Act of 1974, and that was revised, of course, by Buckley, and on through the abuses of soft money and in other ways that brought about the Federal Election Campaign Reform, or the Bipartisan Campaign Reform Act of 2002. It was scandals that led to corruption that led to change. All of that focus was turned on its head by Citizens United, brought as a very narrow as-applied decision, and then broadened out to basically take away almost all of those protections, at least going back to 1907, and then to McCutcheon. Now, I want to make a couple of broad points there, and particularly about McCutcheon. Despite some of the other focal points, what has alarmed me the most about the McCutcheon decision was Justice Roberts basically now taking corruption out of the equation and the appearance of corruption entirely out of the equation and defining corruption in the narrowest way as a quid pro quo that would only be applicable in a case like Abscam or its more popularized American Hustle variety, where you have videotape and an exchange of money in return for a favor. That is so far away from the real world. And in particular now with McCutcheon, where officials, elected officials, can solicit large contributions, something that we tried to restrain deeply in the McCain-Feingold bill. It takes me back to an era that I remember well, where we had presidents' clubs and speakers' clubs and leaders' clubs around here with a menu of access, Give $10,000 and you'd get to meet with all the committee chairs. Give $25,000, you could have a one-on-one with the Speaker. This is a trade of access for money, and it leads down a dangerous path, and a path that becomes even more dangerous when we don't have disclosure of who's involved with a lot of these contributions. And frankly, the notion that McCutcheon is going to enhance disclosure was, I think, blown out of the water by Justice Breyer's very compelling dissent, and what we've already seen happening within a day after McCutcheon was passed, where high-priced lawyers, some of whom are in this room, are working very feverishly to make sure that these contributions get channeled through multiple committees back and forth in different ways so that we won't have any effective disclosure. Let me end with just a few recommendations for the committee or for what Congress could do from now on. First, Congress should make every effort to pass the Disclose Act. Let's get some reasonable disclosure. Second, the Senate should hold public hearings and this committee on the dysfunctional Federal Election Commission and look to reform it to make it a reasonably functional body that acts to enforce the law and not to thwart it. Third, for every hearing that we see on the purported scandal at the IRS, which is trying to apply the law now, which says that organizations called 501c4s shall be exclusively social welfare organizations, we should have a hearing on the real meaning of social welfare organizations and the need to clarify those regulations. Fourth, the Senate should pass a rule amending its ethics code to make it a violation for senators or senior staffers to solicit the large contributions for party committees now allowed under McCutcheon. Next, you should consider the broader reform of the campaign finance system, and I'm delighted that there will be a vote on Senator Udall's constitutional amendment. We have a lot of work and a lot of heavy lifting to do. The next huge scandal is going to bring about a new drive for reform, but before that, I fear that things will get a whole lot worse. Thank you.
Thank you, sir. Mr. Trevor Potter.
Mr. Chairman, thank you for the opportunity to testify today. Senator Roberts, Senator Udall, I appreciate the opportunity to be here to talk about these important issues. I know, Mr. Chairman, that you have said that you'd like the focus to be on the McCutcheon case and the issue of disclosure and the lack of disclosure. I would make two brief points in response to testimony and comments today about the McCain-Feingold law. First, I was pleased to see the endorsement by my colleagues on this panel, Mr. McGahn and Mr. Reif, in their written testimony today of the McCain-Feingold goal of prohibiting, quote, 6- and 7-figure contributions, end quote, to national party committees, quote, in exchange for access to executive branch personnel as well as members of Congress. I agree such huge contributions were and are potentially corrupting and give rise to the appearance of corruption, and thus are bad for our democracy. I worry that they will resurface after the McCutcheon decision through the device of contributions to party committees participating in joint fundraising committees. I also worry that the Supreme Court's majority in Citizens United and McCutcheon does not share the same concern about the corruption inherent in Congress or the executive branch selling access that Mr. McGahn, Mr. Reif, Mr. Ornstein, and I do. My second point about party committees under McCain-Feingold is that they have actually done quite well financially. Look at the picture of two elections, 2000, the last presidential campaign before McCain-Feingold, and 2012, our most recent. In 2000, the two political parties and their presidential candidates raised and spent a combined total of $1.1 billion in that election. A huge sum. Today, adjusted for inflation, that would be $1.45 billion. Compare that to the amount spent in the most recent election by the parties and their candidates. 2012, the total was $2.5 billion, double the actual amount, up 80% in inflation-adjusted dollars. It is true that outside groups also spent significant sums in 2012, but the national party committees and their candidates clearly were well-resourced, better than before McCain-Feingold. In terms of disclosure, or the lack of disclosure, my written testimony describes how we have ended up in a situation where the Supreme Court stated in Citizens United that the importance to our democracy of full disclosure of the sources of campaign funding, but we have less and less of it. My written testimony says that the FEC has deadlocked repeatedly on whether to issue a notice of proposed rulemaking to deal with the question of disclosure after Citizens United. That is correct. The Commission appears to still be deadlocked on this issue. However, I would like to note for the record that the Commission in late 2011 managed to issue a Citizens United rulemaking notice that did not mention disclosure. The Commission even had a hearing. But that is the end of the story. No new regulation, no action on disclosure. Mr. Ornstein's written testimony demonstrates how dramatically disclosure of the sources of funding of public advertising has fallen. In 2004, the first election under McCain-Feingold, 98% of outside groups running campaign ads disclosed their donors. A few years later, that number was down to 34%. In absolute dollars, the amount spent on advertising, only 40% was disclosed as to source in 2012 by these outside groups. Why is this a problem? Let me turn to Justice Kennedy's explanation in Citizens United. He said, "With the advent of the Internet, prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are, quote, in the pocket of so-called moneyed interests. The First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporate entities in a proper way. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages." So Justice Kennedy said the deal was unlimited independent expenditures, but full disclosure of funders. And today, we have only half the deal. And as Justice Kennedy says, speaking for 8 justices, that is a problem for our democracy. How can shareholders hold their corporations accountable for the shareholder money spent in political campaigns if they have no idea what is being spent and for and against which candidates? How can voters hold elected officials accountable if they do not know which moneyed interests are financing those officials' election? Finally, how can the electorate, voters, make informed decisions and give proper weight to different speakers and messages, as Justice Kennedy says, something that the court says is important to the functioning of our democracy, if voters do not know who is financing the constant barrage of advertising run by these groups? Thank you, Mr. Chairman.
Thank you, Mr. Potter. Our next panel member is Ann Ravel, former chair of the California Fair Political Practices Commission and currently vice chair of the Federal Election Commission. Ms. Ravel, thank you for joining us.
Thank you, Mr. Chairman, Ranking Member Roberts, and Senator Udall. Thank you for inviting me to testify today. As indicated, I am the vice chair of the Federal Election Commission, but I am not testifying in that capacity today, nor am I speaking for the commission. Instead, my testimony concerns a case pursued during my tenure as chair of the California Fair Political Practices Commission, FPPC, to expose dark money in a California election. FPPC versus Americans for Responsible Leadership, and I'm going to use the word of the day, is a Byzantine story of campaign contributions being funneled all over the country in an apparent effort to avoid revealing to the public who is behind political campaigns. We discovered that networks of nonprofits anonymously injected millions of dollars into our election by using shell corporate entities, wire transfers, and fund swapping. This allowed donors to skirt disclosure laws and cloak their identities from the public view. Just a few weeks before the 2012 election, a California Political Action Committee, which was focused on supporting one and defeating another ballot measure, received an $11 million contribution. This was the largest anonymous contribution ever made in the history of California elections. The contribution came from an Arizona nonprofit, Americans for Responsible Leadership, or ARL, which had never before spent a dime in California. After a complaint was filed with the FPPC, we attempted to determine whether ARL abided by the requirements of California law to disclose the source of the contribution. We eventually had to seek relief in court. The California Supreme Court ruled unanimously on an emergency Sunday session that ARL had to hand over its records. Because of this, the day before the election, ARL revealed that the sources of the $11 million were two other nonprofits, one based in Virginia and another in Arizona called CPPR. ARL admitted that it functioned solely as an intermediary to receive the money from the two nonprofits and funnel it to the California Political Action Committee. This is a clear violation of the law that prohibits making contributions in the name of another. After the election, a full investigation found that approximately $25 million raised from California donors who wished to remain anonymous went to the Virginia nonprofit and then was transferred to the other nonprofit, CPPR. There was a tacit understanding that CPPR would direct other funds back to California in the same amount or more through an intricate web of groups. After passing through multiple nonprofits around the country, $15 million was then returned to California to the original political committees to spend on the ballot measures. $11 million of that money was funneled through ARL and $4 million through an Iowa nonprofit. Because of the FPPC litigation that was pending, the remaining $10 million of the original $25 million raised from the California donors was not anonymously pumped back into the California election. The FPPC, which is a bipartisan commission, unanimously levied a record-setting fine of $1 million and also sought disgorgement from the recipient committees of the $15 million in improperly disclosed funds. The FPPC's investigation and litigation demonstrates clearly that public officials from both parties can work together to uphold disclosure laws. But the story of FPPC versus ARL also shows that dark money is a national problem that is best solved on the federal level. I'd be glad to answer your questions about this case. Thank you again for the opportunity to speak.
Thank you for joining us today. Finally, Neil P. Reef, as I mentioned, a lawyer here in Washington and former Deputy General Counsel for the Democratic National Committee. Mr. Reef.
Mr. Chairman, thank you for the opportunity to testify today. I'm here today as a practitioner in the field of campaign finance law, and I represent over 40 Democratic state party committees. As our recent article explains, McCain-Feingold has had a profound effect on state and local party committees, and I'd like to provide a couple of examples that illustrate how the law has federalized most of the state party's activities in connection with state and local elections. As Mr. McGahn said, it ought to be revisited. In our article, we agreed that national party soft money ban and the limitation on solicitations by national party officers, federal candidates, and office holders achieved the goals to address soft money practices at the national level at the time of its passage. However, Congress could have and should have stopped there. Instead, with little forethought to its consequences, McCain-Feingold extended its reach to state and local party committees who, unlike national party committees, were thoroughly invested and active in state and local elections. Under McCain-Feingold, state parties have been subject to a labyrinth of regulation that seeks to intercept all of their activities and force them into the federal system, regardless of whether those activities have any relation to federal elections or candidates. McCain-Feingold federalized all elections through its introduction of a new term, federal election activity, which subjected traditionally local activities such as voter registration and get out the vote to federal regulation and limitation. The implementation of this new concept has proven rocky. When passed, it was claimed to be a narrowly targeted anti-circumvention measure. Defense of the law followed suit and minimized the reach of the new law. After the law was upheld in McConnell versus FEC, however, supporters changed their tune and argued that the Federal Election Commission, the agency charged with enforcing the law, was not reading the new mandates broadly enough. Additional litigation ensued, and courts instructed the FEC to rewrite and broaden its rules governing state and local parties. For example, under the FEC's recently redefined definition of get out the vote, essentially all public communications undertaken by a state party committee, even those made totally independent of any federal candidate involvement, are subject to federal law, merely by exhorting the voter to go vote for a state or local candidate. Therefore, if a party committee wishes to air a television or radio ad that tells listeners or viewers to go vote for Smith for governor, federal law may mandate that this advertisement be paid for entirely or in part with federally regulated funds. Prior to McCain-Feingold, state law governs state or local candidate support. But today, parties are governed by federal law, whereas a non-party group could run the same exact advertisement free of such federal limitation. In addition, under the FEC get out the vote definition, if a party committee sends out a mailing on behalf of a state or local candidate and merely informs the voter on when the polls are open, the location of their polling place, or how to obtain an absentee ballot, federal law regulates and limits the funding of the mail piece based upon the provision of such information in the mailer, even when the mailing makes no reference to any federal candidate. It is common practice for state parties to avoid including such information in mailings in order to avoid federalizing those communications. Simply put, party committees have been muzzled when it comes to their ability to inform voters of the most basic voting information if they want to avoid being subject to federal regulation. We cannot conceive of any policy justification that would support this, particularly when other groups who engage in the exact same sort of activity do so without such regulation. McCain-Feingold has had other detrimental effects. Its federalization of state parties has created disincentives for state parties to run joint campaigns that feature the entire party ticket. Prior to McCain-Feingold, it was commonplace for state parties to pay for communications that featured candidates from the top of the ticket to the bottom of the ticket. In addition, state and local candidates have bypassed party committees when engaging in advocacy and get-out-the-vote activities due to the incompatibility of federal and state law. The current structure of the law has caused a significant demise in state and local party relevancy as funding sources seek out less regulated organizations, such as federal, state, and local super PACs, who may independently spend money without any restriction on how those communications are funded and how much voting information that they can provide. The demise of parties has had serious implications for the American political system. Party committees have played a vital role in grassroots campaigning. Historically, parties have been instrumental in delivering positive party messaging and increasing turnout in American elections through grassroots voter contact methods. Now, what some may characterize as single-issue outside groups have come in to fill the void. Although such activities are perfectly legal, it seems to be exactly the opposite system of what was envisioned by proponents of reform. Recently, the Association of State Democratic Chairs passed a unanimous resolution of its meeting in November of last year that calls on Congress and the FEC to reevaluate how state and local party committees are regulated. We have provided a copy of this resolution and legislative recommendations made by the ASDC for your review. None of the proposals made by the ASDC advocate for the repeal of any contribution limit. Rather, the ASDC seeks common sense regulation that balances the need to have vital party organizations along with the need to provide safeguards against political corruption. Although Mr. McGahn and I each have a number of ideas and suggestions regarding specific changes to the law, we both believe that any common sense steps to help revitalize state and local party committees would be helpful, and I have a few examples. Refine and simplify the existing volunteer exemptions for grassroots activities to make them easier to use by state party committees and consider expanding them to other modes of grassroots activities. Repeal the McCain-Feingold provisions that have needlessly federalized joint and non-federal campaign activities undertaken by state party committees. In the alternative, modify the FEC's current interpretation of the existing rules to scale back their expansive scope, that essentially federalizes all party campaigning on behalf of state and local candidates. And finally, index contribution limits to party committees, as these limits were inexplicably excluded from the contribution indexing provisions provided for by McCain-Feingold. Similarly, to the extent that limitations on coordinated party expenditures are still required, update those limits to more closely reflect modern economic reality. In the short time we have today, we can only briefly touch upon the Byzantine nature of federal regulation that state parties are subject to. Thank you for the opportunity to present our views.
Thank you, Mr. Reif. We're going to have 7-minute question rounds. I'd like to begin. First, the term Byzantine has been used a couple of times. This is a chart prepared by the Center for Responsive Politics that is a chart of money in 2012. I think we're insulting the Byzantines, frankly, by blanketing this to their conduct. This chart will be available in larger form, but it's illustrative of what's going on. I did a rough calculation. There's $300 or $400 million here that's flowing through all of these various organizations. They've even come up with a name which I think is a marvelous one, a disregarded entity. That's a kind of, I don't know quite what that's an oxymoron, I would think. Mr. Ornstein, in preparing for this hearing, to coin a phrase, my conclusion was it's worse than I thought. We got a report just yesterday from the Wesleyan Media Project, which is a very interesting project that doesn't try to track contributions because a lot of them aren't disclosed, but tracks ads on television all over the country and then attributes a value to them based upon estimated value based upon the airtime in the media market. And of course, it's only airtime. It's not production or other costs. But the startling thing, this is spending by non-disclosure groups cycle to date. In other words, to April 29th, yesterday. And what struck me is the gigantic growth in these independent expenditures. And that's what I meant in my opening statement, that this isn't a little incremental change. This is a revolutionary change. And the same thing goes is this is non-disclosure money cycle to date. This is outside spending cycle to date, and these are the off-year elections. And you can see between 2010 and 2014 an enormous growth, almost 10 times more. Would you say that this is an accelerating problem, and that's one of the reasons we should have to address it?
It's an exploding problem, Mr. Chairman, and I think what we've seen is a set of very often explicit efforts to try to hide where the money is coming from. It's not only through these, I won't call them Byzantine, bizarre sets of arrangements, and Ann, I think, described very well how this can play out across many state lines. I only briefly alluded to the role of the IRS in all of this, and one thing that we know is that moving towards 2012, there was another explosion, which was applications for 501c4 status from groups that in many cases, and we knew leading up to this, were moving in to influence elections and were using that IRS status simply to hide the names of donors. We know that American Crossroads created another entity, Crossroads GPS, and basically the head of it said very clearly, this is for people who don't want to disclose. So lots of groups moved in there. The IRS, in a pretty ham-handed way, tried to deal with this explosion by using code words. But of course, the reality is if you have a group that has the name party in it, and they say in their application that they want to influence elections, they should be registering under Section 527 of the code. And now the IRS is moving to try and come up with common sense regulations that keeps these sham groups that are not social welfare organizations in any way, shape, and form from doing what the law intended, and they're being attacked viciously for
We
it.
all remember the Swift Vote Veterans for Truth in 2004. That was a 527. but that required disclosure of donors. That, as I understand it, that vehicle is atrophied and is very rarely used, and now it's the 501c4s, which don't require disclosure of donors, and that's where all the money seems to be going. Is that correct?
That's correct, and then some of the other 501Cs may be used as well. But we know that in 2000, before McCain-Feingold, Congress actually did move to try and require disclosure, more disclosure from 527s. It's also important to emphasize what Trevor Potter put very eloquently into his testimony, which is so much of the problem here is not based on either the law or the court, which is very much in favor of disclosure. It's a Federal Election Commission which has tried to redefine, take Pat Moynihan's term of defining deviancy down. They've tried to define disclosure down to make it even more difficult, and that's a root of some of the problems here as well.
Mr. Potter, as I went back and looked at Citizens United and McCutcheon, it was clear that the whole holding was based upon a premise of vigorous disclosure. That was how the courts justified, those two courts justified eliminating the limits, but they posit a disclosure regimen that doesn't exist. Is that correct?
Yeah, I think one of the, as an outsider, one of the mysteries to the Supreme Court's decision in Citizens United is the very strong language by Justice Kennedy where he says, until today, we have not had a system with unlimited corporate spending but full disclosure. And now that we have corporate spending allowed in federal elections and full disclosure, and then he goes on, as I quoted, citizens will be able to figure out who's spending the money, shareholders will know what their corporations are up to. So the question is, why did Justice Kennedy say that? I think the answer is pretty clear, which is he's looking at the law. He's looking at McCain-Feingold, the Bipartisan Campaign Act, which requires disclosure of the sources of spending of advertising if somebody gives more than $1,000 to the groups that are doing it, or if it's done through a separate group they set up for that spending.
But before my time expires, the issue about disclosure is, as I've heard it articulated, that if donors' names are disclosed, they'll be subject to intimidation and threats and those kinds of things. My old colleague from Virginia Law School, who I know as Nino Scalia, I understand is now Antonin Scalia, said requiring people to stand up in public for their political acts fosters civic courage without which democracy is doomed. In Maine, we have town meetings every spring. Nobody's allowed to go to a Maine town meeting with a bag over their head. If they're going to make a speech, they have to acknowledge who they are, and that's part of the information that the voters need, it seems to be. Mr. Ornstein, what do you think? What do you make of this argument that disclosure will lead to reactions and intimidation and threats?
I agree with Justice Scalia very much on this front. I must say, Mr. Chairman, as I've been watching the pictures from Ukraine, and you see these people not with bags but with masks over their heads, it made me think about this a little bit, that there are societies where they try to hide identities. That's not what America's all about. And some of the discussion here that goes back to a case involving the NAACP is really not a very good parallel. It's one thing if you have threats of death and the like, but in a democracy where there is rough and tumble, and it's something actually that I think both Senator Roberts and Senator Cruz talked about, that's the nature of democracy. If you're going to be involved in this process and somebody's going to criticize you for it, there's nothing wrong with that. You have to have some reasonable limits, it is true. If you do have direct intimidation, but there are laws very much that guard against that already on the books.
Thank you. Senator Roberts?
I would just like to observe that no one spending money exercising their First Amendment rights, to my knowledge, is endorsing fire in theaters or pornography or noise pollution. I suspect, however, that many on both sides of the aisle have characterized their opponents as stating noise pollution or, conducting themselves with regards to noise pollution. The other thing I would say is the exercise of free speech that one disagrees with is not pornography, although we all know it when we see it. when we put on our partisan glasses, nor is it necessary to label repeatedly to characterize those with whom you disagree as un-American. Mr. Ornstein, Norm, the IRS is not moving to promulgate the regulations that were in place, the exact regulations that were in place that some of us believe caused the problem with the IRS trampling on the rights, the First Amendment rights of some conservative groups, primarily the Tea Party. They're not moving because they received over 200,000 comments, and by law you got to go through them, and so they've stopped. But they've also stopped because Senator Flake of Arizona and myself at least suggested to John Koskinson, the new Commissioner of IRS, that it might be a good thing to withhold writing the regulations until the Finance Committee of the United States Senate, Ways and Committees of the House, and the Inspector General would get done with the investigations. We're having problems like every other investigation with redaction and other things, but we are persevering and we're trying to do it in a bipartisan manner, more especially with the Senate Finance Committee. So they have held off right now, and I think that's a good idea, and I think once we finish the investigations, we can determine what actually happened. I have some feeling about that as to where that really came from, and I think it came from more than a number of senators writing basically to the IRS, stating that they felt the activities of various groups were not in keeping with what they envisioned the provision to call for. But that aside, I just wanted to mention that. You referenced the Hatch Act. Yesterday it was announced that an FEC attorney resigned for admitted violations of the Act. According to a release from the Office of Special Counsel, the employee posted dozens of partisan political tweets, including many soliciting campaign contribution to the President's 2012 election campaign and other political campaigns, despite the Hatch Act restrictions that prohibit the FEC and other further restricted employees from such activity. The employee also participated in a Huffington Post live internet broadcast via webcam as an FEC facility, criticizing the Republican Party and then the presidential candidate of Republicans at that time, Mitt Romney. I think you can understand why reports of this nature make Republicans somewhat wary of the FEC and their ability to regulate their behavior. Are we to believe that there are not others at the Commission who share these views but just haven't been caught expressing them? Now, I mentioned you, Norm, but really that question is directed to Ms. Revelle, who I think could give a better answer, although I'm sure you could give a good answer.
Well, as I indicated, Senator Roberts, I can't speak on behalf of the FEC, but I will tell you that the FEC responded very quickly to that issue when it came to the attention of people within the agency and understood that it was totally inappropriate behavior on the behalf of an employee. And further, there's been an investigation internally, and there's no reason to believe that this is extensive or goes beyond anybody except this one individual who has since been terminated.
That was my next question, and you've already answered it. My question was, in your experience at the Commission, are any negative views of the Republican Party widespread among the employees there or members of the FEC? Even sitting around and having coffee and saying, my God, what are those crazy Republicans doing now?
Senator,
or what Roberts is doing, or whatever.
I have never heard your name mentioned at the FEC.
At least I'm not part of that dark money scandal that's referred to.
No, and as I indicated, I was speaking on behalf of relating to an incident at the case at the FPPC, but I, in my 6 months at the FEC, have never heard any partisan communications by either employees or commissioners. While we all are appointed based on our party.
That must be one agency that's an island in the sun. Mr. McGahn, what do you think about this? What was your experience in this regard? Should we view this as an isolated incident or as evidence of a broader problem?
I saw the news and I was very troubled by it. When the FEC has that issue, I think it's very serious. I think it certainly calls into question what many of the reform lobbyists have sold for years, which is that there is this idea of a nonpartisan staff that can exist, divorced from politics, and provide objective advice and that sort of thing. That being said, what I can say is most of the folks at the FEC play it straight. They show up on time. They do their job well. They're very committed to their job. They don't have an agenda. But there are some folks who seem to get a little carried away with themselves from time to time, and I think that's troubling. The cure for this is, one, the Hatch Act. Two, keep in mind what the FEC is and what it isn't. It's not an independent agency composed of career staff. It is actually 6 persons appointed by the president and confirmed by the Senate. It's not a nonpartisan agency, it's a bipartisan agency. And under the statute, in order for the commission to actually take action, it takes at least 4 of 6 commissioners to confirm that. So if staff get a little carried away, that's not good, but in my view, the commission is then, this is a reason why commissioners need to remain vigilant and really exercise the power that Congress has given them under the statute to run the agency. The idea that the commissioners want to delegate to staff and that sort of thing, I've never been a big fan of that. And I think the unfortunate release that came out yesterday is evidence that my view of the law is sound and that really it shows the wisdom of the original system of the FEC, where the commissioners have to act in a bipartisan manner to avoid one party essentially targeting the other party.
I appreciate that. My time has expired, Mr. Chairman.
Thank you, Senator. Senator Udall.
We look similar.
No, I'm awfully sorry. Senator Klobuchar, welcome to the hearing.
Well, thank you very much, Mr. Chairman. And I had 2 previous hearings, including the Joint Economic Committee, where I'm the Senate Chair, so I apologize for getting here now. But I think this is an incredibly important topic. I thank you for holding this hearing. I thank Justice Stevens for his testimony and his support for a constitutional amendment. I also thank my colleague here, Senator Udall, for his work in leading the constitutional amendment, which I'm a co-sponsor. I'm very troubled by the recent Supreme Court decisions, the McCutcheon decision extending the damage Citizens United caused. In my mind, I look back, I was cleaning out a back room in my house in Minnesota last week and found a bunch of things for my campaigns for Hennepin County Attorney, where Mr. Chairman, we had a $100 limit on contributions in the off-election years and $500 in the election year. I literally found letters where we returned $10 if people had gone over the $100 limit. I then thought of my first days. I found a bunch of stuff from the 2006 Senate campaign where I knew no one to ask money from nationally. I literally went through my entire Rolodex, and I remember setting the all-time Senate record of raising $17,000 from ex-boyfriends. Those days are behind us as we head into this new era after these Supreme Court decisions, and I'm incredibly troubled by these decisions. When you can have a few thousand people be able to give hundreds of thousands of dollars. And I just think it destroys our campaign finance system. And I guess I'll start with you, Mr. Potter. There's been a lot of discussion about what the real world impact of Citizens United has been and how McCutcheon will affect it going forward. Can you describe what trends or major shifts you see in campaign finance since the Citizens United ruling and how McCutcheon will impact those trends in the future?
Yes, thank you, Senator. Well, I think the first trend, which was noted in the chairman's question a moment ago, is that contrary to what the Supreme Court said in Citizens United, we are seeing secret spending. The court's assumption was that although we would have new sources of spending, corporations and then unions, that it would be disclosed and that shareholders and citizens would know who was speaking, could evaluate that speech. And that's what's not happening now because of the FEC's position on what has to be disclosed, because of this proliferation of tax-exempt groups that do not disclose their donors. we've ended up with a parallel avenue of spending in elections, so that essentially if someone wants to influence an election, if they're being solicited for money, the first question is, well, am I willing to have my spending disclosed or not? And if not, then you look at all these vehicles that are available to spend the same money, to run the same ads, but not have it be a matter of public record, so that
Yes, I remember getting
citizens don't know.
$99 contributions in my $100 race for county attorney, and I know that, but this is taking it to a whole different level, as you point out, when there's no disclosure, and the effect that will have. I guess the other question, you took this even a step further, Mr. Ornstein, when you talked about how the definition of corruption is so narrow in the Supreme Court case. It says that we can only regulate donations to prevent actual quid pro quo bribery. Why do you think this is problematic, and should we be able to regulate this?
First of all, let me say you were a great Hennepin County attorney. But beyond that, anybody, I think, who has been around the political process at all knows what happens when you have money intersect with power, and the many ways, indirect and otherwise, that you get corrupting influences. I've had some of your colleagues tell me, in the aftermath not just of Citizens United, but what I think was an equally corrosive decision, Speech Now, that followed it, that created the explosion of the super PACs and in other ways, say that they're visited by somebody who says, I'm representing Americans for a better America, and they've got more money than God. And, you know, pouring in $10 million in the final 2 weeks of a campaign to destroy somebody, that's easy. They really want this amendment. And I don't know what'll happen if somebody opposes them, but that's the reality. And they leave. And human beings are going to think, well, it's one little amendment. Or we'll think, I better raise $10 million, not just what I need for my campaign, but as an insurance fund just in case, because I can't do that in the final 2 weeks of a campaign. That's just one set of examples. Now, in the aftermath of McCutcheon, I can imagine a bunch of people coming in and waving checkbooks and saying, each one of us has checks that can total $3.75 million now that we'll give to the hundreds of committees, the joint fundraising committees, spread it around. And, of course, we'll have candidates we prefer. The notion that this will actually keep the individual limit is out the window. We will all write these checks, but there's one little thing here in the legislative arena that we want in return. You don't have to say it directly, and it won't be on videotape. This is corrupting. We saw it in the Gilded Age, and what I think both Justice Kennedy and Justice Roberts have now done in these decisions is to open up a new Gilded Age.
Mm-hmm. And you, being a political scientist, not just a campaign expert here, understand that one of the problems is we've had people so polarized, you know, whatever special interest is to the left or the right. And one of the things I'm worried about as I looked at this McCutcheon decision, even more than the independent the expenditures decision, is that it'll just play to the polls. It will make it even harder for people to do things in the middle where they have to compromise and they have to be able to kind of go in the face of some of the people from their own base, from their own party, if they're just going to be punished in a big way by major donors. And do you think there's any truth to that?
I think you get, when it comes to big donors, maybe 4 categories of people. There are 2 that represent the polls, and they're trying to use their money as electromagnets to pull people further apart.
Oh, that's a good analogy.
Yeah. A third type are those who may not have a deep ideological interest, but they have pecuniary interests, and they will use money to make money. I frankly am surprised that we don't have more spending by big corporate interests in Washington, because it's the best investment you can make. Put in, you know, $20 million that goes into funding of campaigns, maybe you'll get $1 billion contract out of it. And we'll see more of that now, and I think we're heading down a slippery slope of direct contributions by corporations to candidates. And then maybe you have a category of those who are just looking out for the broader public interest. But I think that's a much smaller category than the other 3.
And I think the last thing I'd raise, no question, and maybe we can go back after you're done, Senator King, but it's just this issue where even when you're making a decision as an elected official to do what you consider the right thing for your state, maybe you have a lot of employees in a certain area and you think it's very important or you think it's the right thing for the country. I think with this lack of trust with all these big contributions, people still will now look at it, even though you know in your heart you made the decision for the right reason, and they look and they see, oh, but you got money from these interests. And I just think even when you're doing it for the right reason, it completely breaks down trust from the public about why you're doing things. And that's one of the major problems and why I support this constitutional amendment.
Thank you. A couple of follow-up questions. In listening to this and thinking about these organizations that essentially are designed to disguise identity, the term identity laundering comes to mind. I mean, that's what's really going on here. It's a reverse on the old idea of money laundering, but Ms. Revel, that was essentially exactly what was going on in your case, where there were donors in California who the money went to Virginia, to Arizona, back to California. It was all about laundering the identity out of that contribution. Isn't that correct?
Yes, Mr. Chair. The initial request for the money in California was, if you want your identity to be known, you can give directly to a PAC. If you do not want your identity to be known and you want to remain anonymous, it can go to this Virginia nonprofit. And so the money that went to the Virginia nonprofit was specifically for the purpose of not revealing identity, and it was then moved circuitously through all the other nonprofits for the same reason.
Mr. Ornstein, thank you. Ms. Revel, that's exactly the way it appeared. Mr. Ornstein, one of the situations is whenever you try to do something about an issue like this, and by the way, I really enjoyed this morning sitting literally in the center between Senator Roberts and Senator Schumer, but when you try to do something, everybody thinks of it in partisan terms. Does this advantage my party versus the other party, my candidate versus the other? But one of this data I referred to that came out yesterday indicates that the gap, the red are the more conservative-leaning groups, the blue are more liberal groups, and the gap between them is diminishing significantly. It was 85 or 90% conservative back in 2010. As you see here, is still a big disproportion in 2012, but the gap is now 60-40. Hopefully, both sides are going to realize that this is a danger. I think this isn't a partisan issue to me. I think this non-disclosed money is a danger to the republic, no matter who it favors one year to the next. As the Old Testament says, if you sow the wind, you'll reap the whirlwind. And I'm afraid that people are sort of saying, okay, right now, today, this benefits my party, but next year or year after that, it could benefit the other party. And that's why I think we need to make a change like this.
You know, it's interesting, Mr. Chairman, that before McCain-Feingold, you really did have a bipartisan consensus on the need for more disclosure. And indeed, when Congress was considering in 2000 requiring more disclosure of 527 groups, we had an overwhelming bipartisan majority support it. One who didn't was the Senate Republican leader, Mitch McConnell. But what Senator McConnell said at the time was he didn't support it because it didn't require enough disclosure, including what he said was a requirement for disclosure from these nonprofit groups, now what we think of as the 501c4s. We have a very different attitude now. It has become more polarized. And I don't see why disclosure should be a partisan issue at this point. I don't see why we can't cut through that. And I do think that this is something where now that there are more avenues for money, people who have interests, and that includes the polar opposites as well on both sides, are going to start to pour more and more money into it. And in many cases, they are going to try and hide where that money's coming from. And one of the things that we've seen is they will often use inappropriate vehicles 501c3s, the pure nonprofits, to then give grants of money to other groups that can go to other groups that can go to other groups that finally end up in a 501c4 that doesn't get disclosed. There are so many opportunities here to hide identities and to hide money. How can voters figure out when a message is coming, who's providing that message, which is a requirement of context to know whether to believe it?
One of the interesting data points in this new study from Wesleyan is that voters tend to put more credit to ads that come from these groups than they do from the candidates, even though they don't know who the groups are. The groups may be Americans for Greener Grass, and voters tend to think, well, it's not a candidate ad, it must be more, have more authority, but they don't know who the money, who's funding Americans for Greener Grass.
You know,
which, by the way, I'm in favor.
One of the things as well, we've talked, and Justice Stevens talked about a level playing field. One of the things that concerns me is that the level playing field is moving very much away from the candidates of both parties, and in a host of ways. Candidates have to raise money in $2,600 increments, and groups that now can spend untold amounts that can pour it in at the end of a campaign when a candidate doesn't have an opportunity to answer those messages have now, I think, an overweening influence. And it's not that that money will necessarily be spent. The threat of spending, unless something is done, is enough. In many cases, we will see actions taken by government behind closed doors or by changing amendments that nobody will know about, without a dime being spent under these circumstances as anonymous groups apply that threat. It's not a good way to run business in a democracy.
Mr. Potter, I thought one of the most interesting moments today was when Senator Cruz said, unlimited contributions and immediate disclosure. React to that concept.
Well, I think there are two different issues here. One is the idea of full and immediate disclosure, which is the one Senator Cruz talked about, I believe, in the context, in fairness to Senator Cruz, in the context of contributions to candidates. The other is the issue of how much candidates should be able to accept as contributions, or party committees which are comprised of candidates, without citizens thinking that they've been bought. And that's been the debate, really since certainly Watergate, where you had million-dollar
But if you have full
contributions.
disclosure, the citizens can make that decision. They can say, look, my candidate took $500,000 from XYZ, and I don't like that.
They can, and that is where we were in the early 70s when there were million-dollar contributions to the Nixon re-election campaign. The reaction was something is being sold or something is being bought for $1 million. The Supreme Court in Buckley said it is not irrational, it is common sense that people will believe that huge contributions are intended to buy access, influence, results, and that people who take them are in some way being bought. So that's why the court in Buckley said it makes perfectly good sense to limit the size of contributions to candidates and party committees because of the perception, the danger and the perception that there is a transaction. So if you have an unlimited contribution that is fully disclosed, you still have the $1 million coming in. And the question, I think, will be for the, Justice Stevens' question is, so what about people who don't have $1 million? They just don't get to buy any access or influence? But that's been the justification for the contribution limits. The debate has been what size should they be. The assumption has been that those contributions will be disclosed, and as far as we know, they are all fully disclosed, but that the independent expenditures that the court allowed in the Buckley decision, which the court said were not going to be corrupting because they would be totally, wholly, completely independent of candidates, would also be fully disclosed. And we've ended up in a way the worst of both worlds there, which is contrary to what the court has said. They're not fully disclosed, as we've discussed, or they need not be. There's an option there. And secondly, they're not wholly, totally, and completely independent of candidates either. The court's assumption was they can't be corrupting because the candidate and parties will have nothing to do with them. But the reality, as we've seen, is that many of these super PACs that are created by former employees of candidates, relatives of candidates. They are in many ways tied to the candidates. Candidates have appeared at events for these, thanked donors for giving to them. So they're not totally, wholly independent as the court expected. So it's not, in that sense, they're not fulfilling the role that the court thought they would.
I think one of the, we've used the word, and this is a subject that really hasn't come up today, we've used the word perception a number of times. I don't think there's much question, and polls support this, that this whole money in politics is part of what is turning off the American people to the process. It's part of what's undermining the confidence and trust in the system, which is ultimately what our system rests upon. And I think that's part of it doesn't have to be a bribe. It just is unseemly, and people realize that. It may be one of the reasons that our collective approval rating around here is below Al-Qaeda. And it just strikes me as it's there hasn't been enough discussion of that, is the underlying distaste for this whole system that is undermining trust and confidence in our government. Senator Klobuchar, you wanted to follow up?
Sure. I was just listening to Mr. Potter. So I'm a big fan of transparency, but I don't think in any way will it solve all the problems, because I think what's going to happen, I want to get it, but it is going to happen. I know it. Certain people will give in certain states where maybe their entity or what they've done isn't as unpopular, and then someone else will give money in another state. They'll just find a way. I think with good disclosure law, they'll have to disclose, but I just don't think it's going to fix the problem of the trust that Senator King just talked about, as well as the amount of money that can be spent and the not just unseemliness. It's a thin line between what's unseemly and what's almost a bribe. So, Mr. Potter, what do you think? Do you think disclosure is enough?
Well, as you point out, if you get full disclosure, you now know what's happening. Will people like what's happening? That's a different question. And it may well be that full disclosure leads the American public to say, only a limited number of people are being able to buy access. These campaigns cost so much that members have to spend so much time raising money, and they're going to spend it logically with the people who have money. So full disclosure doesn't get you everywhere. Full disclosure is, I think, a start to a then fuller discussion of how do we want to finance campaigns.
So you think it's very possible we need to do more than just disclosure?
Oh, absolutely.
Okay, good. But I think that your argument would be that if you have disclosure, then maybe that will more easily lead to other measures.
Right. My concern here, and going back to the McCutcheon decision, my concern is that I think 5 justices on the court are in a position where they are saying, Congress, you can't do more. We've said disclosure is fine, internet disclosure, all that's really great. But unless it is bribery, it's okay. So this intermediate area that the chairman talks about, which is it's unseemly, it diminishes confidence in government, that used to be covered by the, quote, appearance of corruption, the notion that Congress could legislate as it did with soft money, not because there was proof of quid pro quo bribery with people going to jail, but because the unseemliness of 6- and 7-figure contributions, often solicited in terms of, as Mr. Ornstein says, join the chairman's club, have a breakfast meeting with the chairman of the XYZ committee. And Congress said you can't do that because it's bad for the institution and it's bad for public confidence in Congress. And what I worry about is that the 5 justices on the court are saying, too bad. You can't fix that. You can't regulate that. If it's not actual outright bribery, Congress can't prevent that sort of activity. And that seems to me to be a crisis for this institution and public confidence.
Mr. Ornstein.
Senator Klobuchar, I want to add a couple of points to this. One is, when we think about corruption, it goes both ways. And I think one of the problems with removing all the limits is that the pressure on big donors who can no longer say with an umbrella of protection, I've maxed out, being pushed to give more and more. Or in some instances, as we've seen before, being told that if they give to the other side, then mayhem will ensue upon them in the legislative process, is another part of this that's a very real problem. And then what I would also like to say, if you'll give me permission, is Senator Cruz said none of these reforms have done anything except increase corruption. I think it's important to set the record straight in the sense that, you know, Mr. Potter talked about Watergate, and it led to a law that changed the way presidential campaigns were funded. And to me, it is just incontrovertibly clear that for decades after we changed the presidential system, so there were voluntary spending limits, and there were public grants, we had a much cleaner and better system. It fell apart because we didn't adjust those numbers, and it became absurd. There wasn't enough money there. And to be frank, there wasn't enough public support for public money in the campaigns. Now, I think you're absolutely right, Senator King, that, and we have lots of polls that show it, the sense that the public believes that all of politics, and particularly in Washington, is thoroughly corrupt, that citizens don't have much of a say here, that other interests are prevailing, is a corrosive impact, has a corrosive impact on the ability of a democracy to function with legitimacy. And that these two Supreme Court decisions pretty much blithely push that aside, to me is a really troubling development.
And I'm convinced that it's not just a perception issue, which it is, but I think in Minnesota, where we've had some, very strong limits at the local and the state levels, I mentioned the ones I had for county attorney, it made a difference. It makes a difference in the kind of politics. It makes a difference in the civility. It's made a difference in the outcome. It gave us Governor Jesse Ventura, that's for sure, because we had the public funds, but it gave the citizens a say, and we have the highest voter turnout in the country nearly every single year, and a lot of that, I think, is because people can have a better trust in their government, and they don't see that big money, at least at the state level. Speaking of that, Ms. Ravel, you were talking about the dark money in the Virginia and the Arizona and the case that you worked on. One of the things that has been debated is the impact of these decisions on foreign entities to be involved in funding. If you can do this from state to state to state and it's all hidden, do you think that these decisions could make it easier for foreign entities to fund United States elections?
I don't think there's any question about that. One of the positive things about transparency and disclosure for all groups, regardless of their status, tax status, or how they're set up, is that the public will know, or prosecutors could know, whether or not some of the contributions are made illegally, and that includes foreign money.
All right. Just last, a trust issue. Under federal law, super PACs, as you know, are not allowed to coordinate with their candidates' campaigns or coordinate activities. I already see you having a smirk on your face, Mr. Ornstein. But there's been a lot of discussion over the fact that the organizers of some super PACs have had very close ties to candidates that they've supported. This is on both sides. What impact do you think this has on the public's trust of government?
When you have presumed independence and then you see big funders standing behind candidates as they give their speeches, appearing with them at fundraising efforts, riding with them on their private planes and sitting right next to them, and then we have the idea, which is infused in Citizens United, that because they're independent, then these entities can give as much money as they want and we don't need to worry about corruption or the appearance of corruption. It's a big joke, frankly. And for that, we have to thank, as I said, not just Citizens United, but Speech Now.
Right. Thank you very much.
Senator Klobuchar, since you brought up my independent gubernatorial colleague, Jesse Ventura, I have to
Is
say
it true that he once asked you to be his running mate for president?
the answer to that is true.
Okay, good. I just thought we should get that on the record.
And if you'd like to say no to Jesse, you're just welcome to. But it's been attributed to him, I think, one of the most ingenious suggestions on in this issue. He believes that members of Congress should have to wear jackets like NASCAR drivers with their sponsors on the jacket. Only Jesse would come up with an idea as creative as that.
Few would need trench coats, actually.
I want to thank all of you on behalf of the Rules Committee for your important testimony today. I also want to thank the Center for Responsive Politics and the Wesleyan Project for their help, as well as Fred Wertheimer at Common Cause, Demos, and Citizens for Responsibility and Ethics in Washington, who helped develop a lot of the background. This concludes the second panel for today's hearing. Before we adjourn, I'd like to ask unanimous consent that a Supreme Court brief written on this subject by Senators McCain and Whitehouse be included in the record without objection. And also without objection, the hearing record will remain open for 5 business days for additional statements and post-hearing questions submitted in writing for our witnesses to answer. I want to thank my colleagues for participating and joining us in this hearing, sharing their thoughts and comments on this important topic. This hearing of the Rules Committee of the United States Senate is now adjourned.